So what I will do is I will share the roadmap of how we'll go about. I'll share the screen with all of you, and I would suggest that all of you take notes. It is not a very big topic which will go on. So it will basically cover what the history of Copyright Act in India. That will be the background. The second topic will be the international treaties and conventions and how India is a part of it. Third will be the registration of copyright. So how copyright gets registered in India and the procedure registering the copyright outside India. And after that, the concept of bundle rights in a copyright and how a copyright is then distinguished into various parts, including derivative rights. Then next would be protection of copyright in India. And next, after that would be in case if there is a copyright infringement, how do you enforce your copyright in India, including the litigation, the jurisdiction, and how you can safeguard the entire thing. So it is a small topic of 5 pages. I will not take much time. I would suggest all of you to please take out a pen and a paper and note down, because we will be today covering superficially what copyright is in India and the treaties and conventions of the copyright. So I am proceeding now with the history and the legislation covering the IPR Act in India. IPR includes, see, IPR is primarily divided into three types. First would be trademark, which is prominently known to everyone today. I will also go deep into trademark today. Second is copyright, which we are discussing today. Third is designs. Designs is another aspect of the Intellectual Property Act and is growing in India at an exponential rate. Let's first see the first topic, which is the history of Copyright Act in India. So the history of Copyright Act in India can be traced back to its colonial area under the British Empire. So under the British rule, the Copyright Act was implemented here in India, and much before implementation in India, it was exercised in the Great Britain, as in the British Empire. So the Indian Copyright Act 1914 was basically a copy paste of the Copyright Act of England, and it was slightly modified to suit our terms and our culture. Third is that the Copyright Act 1957 was first implemented by the Parliament and came into effect from 21st of January 1958, and since then has been amended 6 times. So the latest amendment which was done was in the year 2012. That was approximately 10 years back was the last amendment. So we'll just go back to it, revise it once more, that the Copyright Act flew from England to India. First was implemented here officially in 1957. From 1957 to 2012, it has been amended 6 times. And the latest amendment which was done was in 2012. So this is a brief background of how the Copyright Act came into India and how it was implemented. Now, second is, once you know the history of what the Copyright Act is and how it was implemented and brought into effect and received parliamentary sanction, second comes is the types of copyright work. So copyright is today distinguished into many types of works predominantly done by artists. So it is divided into literally, the point number one, literary, dramatic, musical, artistic works, softwares, producers of cinematography films, sound recordings, photographs, cinematography films, government work, public undertaking, and international agencies. Now, literary work basically means anything that is written. It may be a book, it may be a script, it may be a novel, it can be anything that you can write. Dramatic work, similar lines. Musical works includes composition of music. Composition of music can be done by any instrument. There is no such restriction. Fourth is artistic work. Artistic work will include paintings or a person who's performing at an event. Even that is one type of an artistic work. Software, a person who codes a software. The software code is copyright. Next is, once you try going to make a film. Film has a lot of aspects of copyrights. I'll come down to it. I'll explain it to you. I'll explain it to you in the third or fourth topic. Sound recordings, photographs, any photograph today you take from your phone is automatically authored by you, because you have taken the photograph and you automatically become the author of that photo. So if you have to give it to someone, you have to transfer it by way of writing and inform them that you have given this photo or any rights pertaining to that photograph to that specific person. Cinematography films we have already discussed. So films will not only include the one which we see in theaters, it also includes all the films available on the OTT platforms, short films, all types of films. The next is the rights provided under the Copyright Act include rights of reproduction of work. So you must have heard of movies. A specific right in a movie gets transferred to someone, then it is dubbed to some other language, remake rights. So a reproduction of an original work can have a different aspect and it can be then reproduced into a lot of different types of works. Next is communication of work to the public, adaptation of the work or translation of the work. The one which I told you, see a movie, if it is done in Hindi, gets translated to some other language. So the remake rights, the dubbing rights, the translation rights all get transferred to the subsequent person or the subsequent licensee in this. Now the scope of duration of a protection involved in a copyright varies on the nature of the protection. So usually what happens is whenever there is a copyright, the copyright today will subsist during my lifetime and plus 60 years from the beginning of the calendar year. So today, if I write a story or a poem or I write a book, so I will definitely be entitled to receive royalties on that book. Plus 60 years after my death, my legal heirs will receive it. The validity of the copyright protection is for lifetime of the author plus 60 years from the beginning of the calendar year. In cases of trademark, the same has to be renewed every 10 years post-registration. So that is one of the biggest difference between copyright and a trademark. So trademark is once you receive an approval or a registration from the registrar, it has to be renewed every 10 years. So it is not for the lifetime. You have to renew it every 10 years so that it is valid and subsisting. Now the next topic would be difference between copyright and trademark. So copyright, as I've told you, will protect literary, dramatic, musical, artistic, and certain other intellectual property works. But trademark protects a company's name and its product names, brand identities like logos and slogans. Now, I'll give you an example of Nike, the shoe manufacturer, and the swoosh sign. So that swoosh sign today is a trademark as well as a copyright. Trademark will be Nike, Nike. The copyright would be the swoosh sign. So there are a lot of aspects where trademarks and copyrights will overlap with each other. So I will just revisit what I have said and come back. History, we have already discussed. We received the Copyright Act and took cues from it from the English law. Types of copyright work, literary, anything in writing, dramatic, anything in writing, musical, anything in music. Artistic works will include a person singing at an event or a painter, software, any type of film. I shouldn't have written cinematography here. Any type of films, sound recordings, any photograph you take, all these come under copyright. Then reproduction of the work. I will come to that in the subsequent topics. Now let's dive into the next topic. Does anyone have any questions here with respect to understanding this aspect? Because this is important.
Software code is the copyright. Is it true even for literary work? For an example, Blogspot or a page on a website, how do you get the software code?
Software code, see, can be created by anyone today. If you write a software for any website, if you're a software developer, there is a concept of work for hire. See, if you're working for yourself, you write a code for someone. Okay, you write a code for yourself, you're developing some software. So that code remains with you because you are the developer. But in case when you are working for a company, the company has a contract with you and then it is a work for hire. So whatever work you do, as in whatever coding you do, is then transferred to the company automatically based on a contract with the company.
Okay, sir.
Yes.
Yes, software code is the copyright you said, and we can write it ourselves. But then for that, we need to be a technical IT technical fellow.
Correct.
Because I am an author, so I have to then take help of the code writer.
Correct.
So what I'm asking is, if we write a blog post, if I write a blog post, for that particular blog post, I have to take a code?
No, for that blog post, code is not required. But if you write something which is important and which you feel should be protected, then a copyright would be required.
No, but then software code itself is the copyright you said.
Correct.
That means I have to get the software code for my one blog post, second blog post, third blog post. Is that so?
No, that is not the case. See, when you design a website for yourself, what generally happens in a website setting is the coder or the person who's developing your website will develop the website for you for a consideration. You will pay him something, correct? Now,
Right.
after that payment, he will give you the rights for that website, that he has sold that website to you for so and so amount. So that code, whatever he's written today, then gets transferred to your name. So for the
That technical language, the code language gets transferred to me.
correct. And for that separate articles or whatever you write, you have to take a separate copyright.
Oh, I have
If
to
you want
apply
protect.
for that copyright separately in
Yes,
a paper form.
correct.
Oh, I see. Okay, thank you.
Any other questions with respect to cinematographic films? See, this is very important. We'll have to first clear this threshold. As in, once the concept of all these elements are clear to us, the entire topic is very easy. So if you have any questions, please ask me. Sure.
I was told that by a copyright consultant, I was told that once you go on net with your writing, that itself becomes a copyright. Only difference is that taking a certificate is has some authenticity, that you have it. If you go in the court of law, you have got a paper in your hand, but otherwise you have to prove that you had written it 1 year before, it's your material, you have to prove it. But the second part is that you write and you become a copyright holder. In that case, you have to prove it yourself.
Correct.
So I don't have to go to copyright office.
No, you don't have to go to the copyright office. See what happens, I'll tell you. I'll also distinguish today between the trademark as well as copyright act in India. So for trademark, what happens is India follows a common law because we were under the British Empire. So whether you register it or not, it's secondary. It automatically becomes yours once you write it. And same applies for trademark. Today, if you start a business today with your name, and you do not register it, let's assume you started it in the year 2000 and in 2020 you did not register it, and subsequently now a new player comes in with the same trademark in 2020, you will still be entitled to protection by the court because here you get the preference of a prior user.
Correct. Okay.
So good, that happens in trademark. And copyright, absolutely, sir. There is one element which is very important. Today, if you write one article every day, it is impossible for you to get a copyright protection for it.
That's it.
So once you write it, you automatically become the author of it.
Right. Thank you, sir.
If you want to share or if you want to safeguard it, the one of I had read one old English law where they had said that write the same thing, as in whatever you want to copyright it, put it in an envelope and then courier it to you.
Oh, okay.
It will have the date. The envelope is not opened. And then if you want to produce it to the court, you can do it directly. And you can prove that you are the original copywriter.
Okay. I should not open it, no?
No, you shouldn't open it. Then it's gone.
Okay,
So
okay. Got it.
Cannot open it.
Yeah, good trick. Thank you very much, sir.
You're welcome. Yes. Now, so any more questions with respect to this? And I'm telling you, ask questions because this is important. You will get a clarity about the trademark and copyright today. So if you're investing time, invest it wisely. So we'll now go to the next topic, which is the international treaties and conventions. Now, this is important because the Berne Conventions for the protection of literary arts and artistic works. Now, the Berne Convention was adopted in the year 1886 and deals with the protection of works and the rights of their authors. It provides creators such as the authors, musicians, poets, painters with a means to control how their works are used by whom and on what terms. So this is important. Berne Convention is known. See, convention which basically means a procedure. So Berne is a place in Switzerland. Convention is a procedure. So whatever procedure was adopted in Berne is known as the Berne Convention. Very simple. So it was primarily made to protect the works and rights of these authors or artists, musicians, poets, and painters. So at that point of time, the scope was very limited because we had not come to the IT age or the information age. Subsequently, the World Intellectual Property Organization's WIPO Treaty was created. Now, this was primarily done as a special agreement under the Berne Convention. So Berne Convention is the mother of all conventions, which deals with the protection of works and the rights of their authors in the digital environment. In addition, the rights recognized by the Berne Conventions, they are granted certain economic rights. The treaty is open to state members of WIPO and the European Community, and there are some almost 200 countries here which are members to this. So once you register your copyright in one country, you automatically get protection under this act to those other countries who are members of WIPO. So it is like a international community, where you take a registration in one country and you also get protection in the others. But eventually, see, if your copyright is today infringed, you have to hire a lawyer to fight it out, despite having a protection. As of 2022, there are 193 contracting parties, as in 100 and almost 200 countries are participant to this. Now let's come to the practical aspect. See, these two elements are important just for information sake. The international treaties and conventions, these are the two most important things, and that is why I've pointed out these two things. There are a lot of other conventions also, which I feel are not relevant today. But the important aspects today is how practically we can deal with the copyright. That we will discuss in the next topic. Reading law and then applying when you are in court, there is a day and night difference. And what I have felt is you can never do litigation by reading a book. So you have to be present in court and apply your mind. And the system there is completely different. So first step is when you have a copyright, now that you've understood what copyright is, how it came to India, how it came to India. Now let's go to the next step, which is the registration of a copyright. So this is basically the third point on which our entire thing hinges. Now registration of a copyright in India by a registrar. So like for litigation, we have courts. There are registrars appointed by the government who grant registration for the copyright. A trademark search is easier and foolproof comparatively to a copyright search, as it is based on keyword and has already registered applied status. So what happens is, for a trademark, let's assume if I want to apply for a trademark with the name Reliance, and I go to the trademark website to search the keyword Reliance. So the probability of me getting Reliance is high, and a lot of people must have applied with the same trade name of Reliance. So it becomes very easy for me to go to the website and then search it, that this is the registered trademark, this has been applied on which date, and the subsequent procedures. But the same principles do not apply in case of a copyright. See, copyright is basically an idea on paper. So it is not in your mind. So anything which is in your mind cannot be a copyright. It has to be on paper. And that is why it becomes difficult to conduct a search for a copyright, which unlike for a trademark. Now, Section 9 of the Copyright Act requires for an establishment of an office called as the Copyright Office. So every state has a copyright office, and these copyright offices grant you registrations. Now the head office here in case of a copyright is in Delhi. Trademarks can be done or registered from any state in India. It's a complete online procedure. Comparatively, the copyright registration process is simpler and can also be done directly by an individual. Now, as I've said earlier, registering an IP outside India, although protection is granted for the copyrighted work, it is applicable to the other countries. You will have to hire a lawyer to enforce your rights in the event of a copyright infringement. So if there is an infringement, even you have the protection, you will have to hire a lawyer to fight your case and assert your rights. And copyright is not refined or restricted to a couple of rights. It considers a whole different types of rights. And now for movies, only for movies or cinematography, films, or any type of film, this is an example of how many rights are there in a film. So first is a satellite rights, which we usually hear in TV or on the news, that so and so movie satellite rights were sold for so and so amount. Second is there are a lot of other rights also: the television broadcasting rights, direct antenna rights, territorial rights, distribution rights. So what happened before the OTT platform came and it was popularized in this decade? Everyone used to go and watch movies in theaters. So what happened is, once a producer had produced a film, he used to give these distribution rights to different people. Now for Maharashtra, there will be a vendor. For Calcutta, there will be a vendor. For Madras, there would be a vendor. For Delhi, there would be a vendor. For Gujarat, there would be a member. So all these rights were distributed by way of these distribution rights, so that these people there as vendors can then distribute the movies there. And not only this, now I am only constrained myself to India, but there are a lot of movies which are also released in other countries and in the theaters, international theaters. So for there, the distribution rights also applies to international vendors. Cable TV rights. I have grown up seeing cable TV. direct to home services, internet rights, video streaming through all forms. Now today, there is an aspect of me going online on Amazon Prime or on Netflix and watching my favorite movie. Okay, I go watch it today. I want to watch it after 5 years. What would happen then? It would be gone from the platform, as in not on Netflix, not on Amazon Prime. So what will I do then? So then there will be definitely some vendor who will be selling these rights, which will be known as video on demand. So I want to see a video. I will then pay him X amount of rupees. He will give me access to watch the film 1 time, 2 times, or 3 times, or for an entire day. I can watch it as many times as I want. So these are the rights, as in when we look at a film, we feel that there are only satellite rights, but that is untrue. There are a lot of other different types of rights in the movies. IPTV, terrestrial rights, laser disc, Blu-ray, all these rights are today not exercised because nobody manufactures discs or Blu-rays. But in the early 2000s, Blu-ray was a rage, which is not today. Today we watch most of it on either on Prime or on Netflix. Cable rights, pay-per-view, remake rights. Remake rights, a lot of South Indian films are today remade in Bollywood. So these are those remake rights. So once when you make a film, you also have to consider a lot of these elements, where these rights come from, whom we can sell these rights, then dubbing rights, railborn, mobile ringtone rights, etc., etc., etc. So there are a lot of other elements which will today come into picture here. Primarily, if I remember seeing the movie Ravan, there was also a video game as an available on the Google platform at that point of time, which was a video game based on Ravan. And a lot of other elements play here, because then the rights of those movies can be sold to some other parties. Like for a movie like Hanuman, you can send the merchandising rights, pens, pencils, bags for children, those can be sold out and then monitored. So a lot of stuff can be done under copyright, which practically trademark and copyright are two boats running side by side, but copyright is a little more deeper as compared to trademark. Now let's go to the next topic, which is also very important, known as concept of bundle rights in copyright. So anyone has any queries with respect to these types of rights, or any questions for registration? You can ask any questions for registration also. Registration, because it's very simple. It is you go to the copyright website, create a user ID, create a password, select which option you fall in, and pay their fees. Fees are different, starting from 500 rupees to 2000 rupees. So it's a very simple procedure. Anyone can do it.
What are the major reasons for rejection of a copyright application, and how we can avoid it?
See, that becomes very difficult. As I told you, for trademark, it is very easy, because if I apply for a trademark under the brand name of Reliance, the registrar himself will tell me, ki, boss, you have seen what a company Reliance is. Why are you applying in the same name? I will reject your trademark. But that doesn't apply in a copyright, because for copyright, you write a script for a movie, I write a script for a movie. There is a hero, there is a heroine in the movie. Same plot, everything remains the plot. Doesn't the plot remains the same? The ending may be different. So I can claim a copyright for a different ending. You can claim a copyright for a different thing. So that becomes very difficult in case of a copyright to sit and adjudicate whether who is the correct copyright holder in case of movies or any copyright element. Unless it is a script where you know ki chalo 2 + 2 = 4, that becomes very easier. Otherwise, in all other aspects, to distinguish which copyright should get influenced or which copyright is prior in time, that is a very diplomatic and difficult explanation today to give to any of you. Because as a registrar, if I am sitting on the chair and there are two applications based on the same plot as a Hindi movie plot, just there is an alternate ending. So it becomes very difficult for me to say, okay, this is different or this is different. Okay, now we'll go to the concept of bundles rights into a copyright. So as I told you, copyright is much more deeper than that of trademark, because trademark is plainly someone comes, copies your trademark, you sue him. Copyright has a lot of other elements inside it. Now we'll take an example today. A song can be divided into 3 parts: the lyricist, the musician, and a singer. Without this, a song cannot be made. Someone has to write the song, someone has to give music to it, and someone has to sing it. So we'll take an example of Kal Ho Na Ho. Kal Ho Na Ho was written by, as in the song was written by Javed Akhtar, music was by Shankar Ehsan Loy, and Sonu Nigam had sung this. And Sony Music had sold, as in the entire album. But the copyright at that time vested with Dharma Productions. And I'll tell you why. See, what happens is Mr. Javed Akhtar has the lyricist, as a lyricist written the song. That is a separate copyright, correct? Today, if you write a song, you can claim copyright. Second is if you are a musician and if you give music, there is a separate copyright. Third is if you are an artist, Sonu Nigam is an artist. Three different people, three different copyright. How do we deal with that? So what happens and what is held by the Copyright Act is three different people come together, create something new. So that song, Kal Ho Na Ho, which includes the efforts of the lyricist, the musician, and the artist, claims a separate copyright. So that it becomes altogether a different copyright, and that copyright then remains with the production. Lyricist, musician, singer, three different people come together, make a song, Kal Ho Na Ho. Sony Music distributes it, but the rights are with Dharma Productions because Dharma has today brought all of them together and taken the rights from them. So this was the situation pre 2012. So where Dharma Productions had all the rights, he said, boss, I am not giving you any royalty, either of you, either to the lyricist, to the musician or the artist. I am not giving you any royalties. You have done it for your consideration. I have paid you 5 lakhs, 10 lakhs, 15 lakhs for the song. Now you transfer the song to me and you go away. I will not give you anything. Now, what happened in the 2012 amendment? The producers exercised absolute rights after the final product was delivered. So the song here is the final product. Kal Ho Na Ho, with the music, with the lyrics, and with Sonu Nigam performing, becomes an entirely different product. So pre 2012, the production house had absolute control over it. However, after the 2012 amendment, the persons holding the derivative rights were entitled to receive royalties. So these people, 1, 2, and 3, are individual performers. So after the 2012 amendment, what happened is the law gave them teeth to claim royalties from the producers. So a lot of producers used to do it. Tapes did it, T-Series did it, and they were famous for it, for not paying royalties to the individual artists. So what happens is if I write a song today, they will pay me a meager maybe 50,000 or 70,000 for the song. Sonu Nigam gets paid 5 lakh rupees. Shankar Ehsan Roy gets paid a crore of rupees for the music. But I am only being compensated for 50,000 rupees when I have written the song. So there had to be a balance which had to be struck out. And this 2012 amendment gave teeth to all of these artists. Now, it not only gave them teeth, it also gave power to the copyright societies to collect royalties on behalf of them. Now, I'll give you a couple of examples also. Indian Performing Rights Societies, IPRS, is one such society primarily for authors, composers, and publishers. So what IPRS does, it says, ki, okay, this song was written by you. You give us authorization to collect royalties wherever this song is played. We will go there. If they are playing the song without any permission, we will issue notices to them and we will collect royalties. So for a simple birthday party or a wedding, and it completely depends on the list of your songs, that comes to around 25,000 rupees. So you have to then take permission from the IPRS saying, ki, look, I have a function, maybe whatever function is, and I want to play these list of songs. I need permission to play these songs. They will then in the list give you the details of the songs, for how long it is being played, and they will calculate the royalties based on it, and you have to pay them that premium fees. The issue of license, they issue licenses and collect royalties on behalf of the artists. So these are the two societies. There is one more, which is Novex. Novex is a private limited company and acts as an agent to the copyright owners for the registration process. So I will just show you Novex's website. So now apply for an NOC. You go click here. Similar procedure in all these societies, copyright societies, where you want to play songs and all. So see, these are their clients. Clients basically who take permissions from them. All the hotels where they have parties or where they are playing songs. So they will provide them with a list. This is our list. These are the songs we want to play. Tell us what the royalty is. We'll pay that. Event managers. Same principles. Retail stores. If they are playing any song, they have to take license. Malls. Wherever we go shopping, we listen to the songs. All those songs are paid songs basically. Gymkhanas, cafe and restaurants, health clubs, corporates, amusement parks, pubs, discos. So this is today a big business. And what happens today, 10 years, 20 years back, when I write a script or I write any lyrics, I get paid 50,000 rupees and then I'm done. Today, I will continuously receive royalties for the rest of my life. Wherever my song is played and whenever it is played. Dance studios. See, Yash Raj Films has contracted them. Eros has. So here you get a list of all these songs and the movie. So you have to select the songs, give them the details, and they will tell you how much royalty you have. So we'll get back now with our topic. So Novex today, Novex Private Limited acts as an agent to the copyright owners and the registration process. So they say you don't have to go to Yash Raj, you don't have to go to individual artists. I will do it for you. You come to me, give me the list. I'll tell you what the royalties are, pay me and use the song. Now the next aspect is protection of copyright. So any questions in this topic? The registration as in the application of applications of copyright in India, internationally, the types of rights. Have you understood the concept of bundle rights? It is very important. And if not, ask me again, please.
Yes, my question is like I write a song, I get copyright, and thereafter, whenever it is played, someone takes permission by the website you have shown, and then there is a royalty which is calculated and it gets paid. Is there a similar arrangement for written material? Whenever it is used by some people, one page used in his book or for whatever his internal consumption, is there a website like this?
No, there is no such website for that. You have to enter into a contract with that person.
I see. Oh, this is only for songs.
This is only for songs, primarily for songs for these three artists, as in the lyricist, the musician, and the singers.
Okay, thank you.
It is more like a building. A building will have 3 rooms, without which the building cannot stand.
I see. There is a scope to then have such a website for a startup, for such whatever website you have shown. There may be some opportunity. Am I right? Got my question?
Yes.
Yeah. There may be an opportunity for a startup to come out with a website like this, where the royalty also can be claimed automatically for written material or rather anything. Why only for songs? There is a scope, I think. Okay, fine. Thank you.
There may be an association which I am not aware. For films, I can tell you, they do not have a website, as in they are not organized as such, but there is an association for the film writers. So whenever a film writer, as in a writer, writes a story, he gives a copy of it to the Films Writers Association. So they have a copy of it, so that nobody copies it, or if somebody copies it, see, they have their own association today. And all the producers are members of those Film Writers Association. So in case of any infringement, they then issue a notice to them, call them for a hearing, and they amongst themselves decide it. So there may also be a possibility here, which I am not aware, but I can tell you one such example of a Film Writers Association.
Okay.
Sir, I have one question that just like in trademark, there is a opposition procedure. So are there like in the copyright registration process, is there any provision for the third party oppositions? And if yes, what is the limitation period for the same?
See, limitation period across all laws is 3 years. First, we'll start with the limitation aspect. Second, for copyright, it becomes very difficult to ascertain whether there is actually an infringement or not. See, you must have heard of many cases where 5 days, 4 days, or a day before the release of the movie, the writer comes in the court and says, this is my script. That is the reason, because it is very difficult to ascertain whether he has actually written it or not. So that gray area is always there for copyright.
Okay, thank you.
So the copyright will always have a gray area. Will always have a gray area, because see, if you have written something, maybe 90% of the elements are same. You write something, I write something, 90% is same. The 10% is different. I can always say for that 10%, I will always have a separate copyright. So then that becomes very difficult. And that is why, see, for trademark, you may see numerous litigations happening in court. But for copyright, for these movies and all, you will always see the person coming on the second last or on the third last day or 1 week before or wherever the promo is out. So when the promo is out, see, he must have written a story. There are a lot of stories which have almost the same plot, correct? So he must have written on plot A, the other one has written a similar thing on that similar plot. So then he has to distinguish how his story is different from the other one, so that he gets an injunction in court. So once he sees the trailer online, he realizes ki, okay, this is my story which I have written, and then today I have to go to the court and get an injunction. He does that. He files a suit in the court. So that is always a last moment thing, because till the last moment nobody can say whether there is an infringement or not, or whether the stories are exactly the same.
Okay, sir.
Have all of you understood regarding this element? Because this is very important today. 2012 changed everything. Now, a lot of people may be having questions in their mind that how do I protect my copyright today? If I am a script writer or if I am a designer, I design logos for companies. I go to meet a prospective clients. I tell him, look, I have designed this, or I have written this script. This is the story area, and this is what will happen. This is what the plot is in the movie, and these are the characters. Now there is a high possibility that if I go and share this with someone, he may like the idea and use it, correct? That there is always a possibility that may happen. So just to stop that, an NDA is executed between the parties. Now, what is an NDA? NDA is a non-disclosure agreement. Non-disclosure agreement, or NDA, as they are sometimes called, are legally enforceable agreements between the parties that are used to ensure that certain information will remain confidential. So if today I am going to meet a producer, I am telling him, look, I have written this script. You have to read it, and if you are interested, you will have to make a movie on it. Okay. Now I go there, I show him the script, I tell him what the story is, but I, back of the mind, know that this guy will go, and if he likes the idea, maybe start a film or something similar of that aspect. So then I sign an NDA with him. NDA is that he will agree that he will not disclose any confidential information to anyone. So NDA is the first step to ensure that your information remains confidential. Now NDA either can be one-sided or two-sided. Now, considering if I go to buy a company, now this is apart from the IPR aspect. I go to buy a company, I show my financials to someone, he will show some financials to me. So he will say, boss, my turnover is so and so, your turnover is so and so. If there is a possibility of a buyout or a merger, we will do it. So now that that person has shared important confidential information with me, and I have shared equally important confidential information with him, both of us will sign a two-sided NDA. One-sided NDA is where I disclose information. Two-sided NDA is where both persons will disclose the information. So any questions with respect to a non-disclosure agreement? This is very important and very basic also. Have any of you signed an NDA before?
Yes, I have signed NDA, but that is only one-sided. So one-sided. So the company who avails my services, they took an NDA from me that wherever they send me, I will not disclose, etc. Blah 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 blah. In this case, I have not taken anything from their side, meaning I am an author also. So if they use my material, they also should. So what in this context, what does the two-sided mean? What should I do?
Two-sided means, sir, there is a possibility where you have given them something, as in some confidential information, and even they have shared some confidential information. So in that case, a two-sided NDA exactly.
No, so in this case, they send me for my expertise.
One-sided.
They avail my services for my expertise, but my expertise, there are some secrets in my books. So when I share that, I want the company, that company who has signed NDA, took a NDA from me, I don't want them to use my model in their consultancy work. So how does it go?
They will not do it because they have already signed an NDA.
But that is one-sided, no? So what does two-sided mean?
Two-sided means where they also share some information with you, and even you agree that you will not share it with someone else.
I see. That means two-sided. Okay, that was my misunderstanding. Okay, fine.
So
So the one which is signed by me, they took from me, duly signed, that means double-sided only.
Correct. See, it completely depends on the flow of information. So if the flow of information is from one side, that is a one-sided NDA. If the flow of information is from both sides, that becomes a two-sided NDA.
Then in that case, that sentence has to be there. Is it two-sided, something like that?
Yes, it has to be.
What is that sentence, for example?
For example, see, for example, you can always write that I have shared so and so information with this. The so and so party has shared this information with me. Under the agreement dated so and so, both parties agree that they will not divulge into any confidential information to any other third parties unless with the written permission of each other.
Okay. So when they ask for something to be written as an NDA, I should insist that this also please you include.
Yeah, of course. If there is information sharing by both sides, both parties, it has to be a two-sided NDA.
Okay. Thank you. Thank you.
Okay. Now,
Yes. What is utmost important part in NDA from present corporate agreement point of view?
see, corporate agreement, what I would suggest is not to put an arbitration clause. Very important. So if you have an NDA, which see what happens is today, because I have worked in a company as I was as a consultant in a company who used to do a lot of these agreements and they used to share a lot of ideas. So production houses, a lot of people coming to them with scripts saying, look, this is my script, this is very unique, have a look at it and then use it if you want to. Pay me some consideration. So that is what is always happens. So what I have understood over a period of time is whenever we draft agreements, we always put an arbitration clause. So arbitration clause somewhere slows down this process because if there is no arbitration clause in these types of agreements, you can directly move court and get a stay. That usually doesn't happen so quickly in an arbitration. So that is one thing what you can avoid.
Okay, sir. Okay.
The important sections we are, I think, almost finalizing it. Almost done. Okay. So important sections about the Copyright Act. Now, section 17 is the first owner of the copyright. So as I've spoken earlier, we have already discussed these points. So discussions before help us to subsequently build up all this. So first owner of a copyright, first owner is someone who writes the script, who sings the song, who performs, is the first owner. Automatically becomes the first owner. No need of a registration, no need of an agreement. The author will be the first owner unless there is a work for hire contract. So I've mentioned earlier that unless you have an agreement with party A or party B or a software developer, in one of the cases which we have discussed, that I go to somewhere, tell him, ki, boss, you designed this website for me, that will purely be a work for hire contract. So he designs everything, he gives it to me, but that is for a consideration and he agrees that he will transfer everything in my name after the assignment is complete. Second important aspect today, assignment of a copyright. Now, if I want to give the copyright to someone, what are the three basic elements which are important for the transfer of copyright? Now, for the transfer of copyright, first important aspect is it has to be in writing. So I cannot orally transfer anything to anyone when it comes to a copyright. Second is assignment can be done either wholly or partially. As we've seen the different types of rights in movies, satellite, cable, VOD, Blu-ray, all different types of rights. So if I today agree or if I today channelize ki, okay, I will sell only one set of rights to someone, I can still do it. I am within the preview and I am entitled to do it. Third is assignment will not waive off royalties. Like it happened in the music companies where the lyricists, the musicians, the artists who were performing, they had taken an NOC from them that they will not claim royalties for the songs. But see what is mentioned in the law has to be followed. So any agreement against the law is void, null and void. Third, we also 33, we discussed about the registration of copyright society, IPRS, how they collect revenue, as in how they collect the royalties from the people and how it has the power to issue licenses on behalf of the authors. That is also what we've discussed. We've also discussed how we can make an application before Novex and take rights for the songs. 38 is performer's right. Now somebody had asked me, what if I am playing a song before, as in I'm singing a song before a people for no consideration. See what happens is if you are today singing a song like Sonu Nigam today singing Kal Ho Na Ho before a crowd, he does not have to take any permissions from anyone because a live performance itself is a new copyright. So today if you stand in front of the audience, a large audience where you are singing live, you don't have to take permissions from anyone because the copyright is being created live. So all the other principles what I've told will not apply in this case because a performer's right is a completely separate right and it is not bound by any other producers or any other association. So he is at liberty. He can go to any event and sing. He need not take any permission from any IPRS, anyone, because there, if he's singing live, a lot of people are already performing with him parallelly and who are giving music to him. So it altogether creates a different copyright. Like in the case of producer, the producer had all the copyrights because he was the producer and he had brought all those three people together. Now for a live performance, the same principles will apply. So any questions on this? I remember somebody had asked the question.
Sir, namaskar.
Namaskar.
Sir, this is regarding NDA. Just you elaborately discuss on it. So my question is, while we go for bilateral NDA, and you told ki avoid the arbitration clause in order to avoid future legal consequences, anything
Yes.
happen. So whether it is a right way to approach, avoid the arbitration clause out of it, because we are now moving in a world where compromises and all things are happening. And if in bilateral agreement, if other party insists that you should put the arbitration clause there, then what will be our take away from it?
Sir, what happens is there you will have to negotiate not to put the arbitration clause. See, you will always be at liberty once you go to court. See, arbitration agreement is such that it is with the consent of both parties. Today, if you move
Right.
court, you get the relief immediately. It's okay. Once you get the relief, you can always tell the court that I am ready to go for arbitration. Now convert this application of mine and where I have got a stay to convert it into an arbitration. So you are not stopped.
Okay. So in order to protect my NDAs, whatever you mentioned there, I will get relief without arbitration easily. That is what.
Very easily, because then you directly move to see what happens is when you go to court today, what you said is absolutely correct, but that is also an hindrance to me. You go to the court,
Correct.
the judge first asks, is there an arbitration clause?
Barabar. Because why I am asking, because I'm in the corporates, we used to do a lot of agreements with foreign vendors and
Correct.
suppliers and all the things. So I am part of the core team who draft it very rigorously.
No, what happens is, see, that is what I'm telling you, sir. You go to the court will ask you the first question, if there an arbitration clause. The answer is yes. He says, ki, boss, you go to arbitration. I do not have the jurisdiction to entertain. Now
Right.
you go to appoint the arbitrator. That is a lot of hassle. That will take at least a week of time. Then you again have to go to the court. The other side will not agree. So just to safeguard their interest, no arbitration clause. Once you move court, you get an injunction. You can always say, okay, I'll go to arbitration today. Send me to arbitration. You appoint
Correct. Other para services will be available to us.
Perfect. So you are one step ahead. As
Right,
in the
sir. Thank
RTO,
you
not the company.
Correct. Thank you so much, sir. Thank you.
Sir,
So-
one more question is there.
Haji.
When and how we will come to know if anybody is trying to apply for the same brand name which my client has?
That is only possible in case of a trademark, madam. Copyright is very difficult.
Okay, sir.
Because as I told you, ma'am, you write a script, I write a script, I send it to the copyright agency, they approve your script, they also approve mine. So even if there's a 5% difference, they will approve it. They will give me a copyright registration. But that doesn't help actually. In practicality, that doesn't help. So this session was not only about giving you a superficial knowledge of what copyright is, but what actually happens in court. Now, as sir asked me about the arbitration clause, he's absolutely correct when he says we have to go through a specific mechanism. But when practicality comes, I have seen clients whose scripts have been stolen and they couldn't do anything because there was an arbitration clause. And by the time something happened, the movie was already released, then nothing could have been done. The ship had sunk at that time. Very well. So enforcement, second last topic, we'll discuss this. Enforcement of copyright in India. So the Copyright Act 1957 provides three kinds of remedies: administrative, civil, and criminal. So you have to go to court basically if you know either your script, your song, or your book which has been published, or any such design that has to be then considered by the court and appropriate action has to be passed. Now, the administrative remedies under the statute includes detention of the infringed goods by the custom authorities or by a court receiver who is appointed by the court. Next is the civil remedies are provided under chapter so and so, and the remedies provided including damages and accounts of profits. The criminal remedies are provided in article so and so, and against the copyright infringement include imprisonment for 3 years along with fine of rupees 2 lakhs. Imprisonment, I have never seen anyone go to prison because of this. They must have paid a fine and then they get out. That is what happens practically. So when you move court, now assumingly someone has stolen your idea, you have to then establish your case based on these three principles. First principle is that irreparable harm or damage will be caused to you. Second is you have made out a prima facie case that there has been an infringement. And third is balance of convenience. Balance of convenience would be to demonstrate that you cannot be today compensated in terms of money. So if a movie today is released out, like happened in one of my cases, when the movie was released, there was no practical relief or anything which could have compensated the client. Then we'll go to the next topic, which is jurisdiction. So jurisdiction is basically where you sue the infringing party. So jurisdiction under the Copyright Act in 2015 regarding the Copyright Act violation underwent a significant change to the judgment of so and so. If the cause of action has arisen wholly or partly in that area where the plaintiff resides or is doing business, the suit has to be filed at such place. So because see what happens today is because of the internet, I can always say, despite my office being in Mumbai, just to inconvenience the defendant, I can always tell that someone saw this in my regional office in Calcutta, and because of that, I have now today moved in Calcutta. So that causes a great inconvenience for the defendant. So this judgment of IPRS versus Sanjay Dalia clarifies that point, that the plaintiff has to file a suit where the plaintiff resides or is doing a business, so that he cannot take the defendant to some other area, some Uttaranchal or some remote area, just to inconvenience him. So this was the last topic which we had covered. So any questions on any of these topics?
What is a copyright notation? Do I have to use a copyright notation on all my copies of work?
Copyright notation will be a sanction, basically a sanction from an authority or a registrar. So it is not required. See, once you publish a book or something, that becomes important, that you mention all these details. See, any book you take, you flip those pages, you will always see that it is registered under copyright under so and so, so and so. So it becomes an important aspect in books. But when you write an article, it is impossible. Like I draft something, I write something, at least 10-15 pages in a day. It is impossible for me to take a copyright for it in all these aspects. But whether you take it or not, you are always the author of the work which you have written, and you do not need to publish it.
Sir, do copyright laws applicable on research papers?
Yes.
If someone copies a few video files from someone else, which is not a song or a movie audio, will he or she still be getting a copyright claim?
Yes. If the author who's recorded it finds it infringing, he can definitely get it.
Okay, sir. Okay. Sir, what are the possible exceptions to infringement under the Copyright Act?
Possible exceptions are if there is some parody
Yes.
or some comedy which is done. That is one of the exceptions under the Copyright Act.
Sir, my question is that while I was doing my LLM final year, I had a research paper there, and I did research on company secretarial audit and overview there. And I put everything there in my law college, and I made a presentation there. Key company secretarial audit should be made mandatory to a certain kind of company which was already existing there, but I representation there, it should be mandatory to more companies, irrespective of the criteria mentioned there. And now after I put that paper in 2015, and now government has come up with guidelines that it has become compulsory to more entities. The government has, I can say, very liberalized on that issue, and making mandatory to all companies who have a borrowing of 100 crores, irrespective of other capital area. So I made that presentation in 2015. So whether I can ask the government that this was my submission there, and how, what is your takeaway, sir?
So you are saying you had suggested something and the government has implemented it?
Yes, sir. Indirectly, sir, I come see this is happening now because the company secretary audit has been more liberalized there. Because earlier there was not borrowing criteria was not there, and I mentioned in research paper that it should be made to all corporates, irrespective of the criteria mentioned earlier.
Understood. Understood. So this will not be a copyright infringement. This is an idea, and secondly, this is a government policy decision. So anyone's copyright cannot today infringe a government decision. So government is always at liberty to take its decision without any aspect of copyright infringement coming.
in case copyright infringement also there, if it is a policy matter, then government can do it their own.
Yes, of course, of course. Policy matters, government can do anything it wants.
Okay. Thank you lots.
Two things. One is you said video and picture. Video and picture has got its own date and place on our cell phone, let's say. Now you have to ensure when you transfer this, sometimes that place, time, date and time goes away. Now you have to ensure that that place, date and time has to be with the recorder. Am I right? As a record.
Not
in
necessary.
order to necessary is necessary, right?
Not necessary.
Not necessary. So how do you prove the source then that I had taken the picture?
That is what you can always do, sir. If you have made a movie, let's suppose in the 1980s, you want to publish it today, you can always do today, stating you have to give the user date when you started doing it, or when you had first created it, and accordingly it will get the registration.
A simple thing, where you said that earlier, paper return material you mail to yourself and retain it for the court. Can I do the same thing by sending the picture to myself on WhatsApp and keep that as a record that on this date at this time I had taken it and I'm sending it to myself? Can I use that?
Yes, you can. You can email it to yourself.
Okay, great. That is one question.
Email it to yourself, email it to some other people or whom you trust, so that even he has a record.
Right. Second question is, some time ago on the TV, some part of my book cover page was used, and then I approached an advocate. But it so happened that that advocate somehow managed to get in touch with them. And I don't know what happened thereafter. That immediately went off the next episode that my material went off the broadcasting. In such case, what does one do when this happens? He has to record the proceedings of the first episode, that episode where it was published, and that recording can be used. That is one possibility. But if you have not recorded, what do you do in that case?
If you have not recorded, you can always call from them that I have seen this video, or I have seen this so-and-so clip of yours, and based of which I am asking you for a disclosure. If he doesn't give disclosure, then you'll have to file a suit to get it.
I see.
It's a complicated process. See, unless it is very very lucrative, I would suggest not to go ahead with it.
I understand. Thank you for this.
So litigation is where you can avoid litigation. That is the best thing.
Thank you. Yes, thank you.
Sir, could you please elaborate a little more on performers' rights and who all are entitled to such rights?
Performers' rights are, see, what happens is performers' rights are primarily created for live performances. So today, if someone is playing live, that becomes a performer's right. So any person today, see, there are a lot of events today. Some people, for example, Sonu Nigam or Euphoria or Lucky Ali, who has sung songs 20 years ago, can today go to any Shanmukhanand Hall and sing the songs whatever he wants without any approval from anyone. And today, if you record something, that becomes your copy.
For training material on paralegal skills, can we get copyright for book written by me?
Yes.
Any concluding remarks from your end, sir?
The concluding topic today, see, copyright today will only extend. But before 2000s, we used to read everything on books. Today there is Kindle, and subsequently, I feel is what software will replace hardware with everything, and that is where copyright will play a very important function. Now, 10-20 years back, I used to transfer songs from that laser infrared thing from one phone to another. Then 10 years back it was Bluetooth, now it is Wi-Fi. The technology will improve. Before 2007 there were no apps, nobody knew what apps were, and after 2007, after iPhone came, there were apps everywhere. Today there is an app for everything. So this domain of copyright will only increase day by day. Like for the movies, all of you saw the different types of rights in the movies. So nobody had expected this some 20 years back, because there were a couple of rights like the satellite rights, the cable rights, the DVD rights. That is all limited to not more than 10 things. And today there are thousands of rights which can be licensed and monetized today. So copyright, I feel today will garner, as in with time, when it goes, copyright will become an important aspect, not only in the legal thing, but also in our personal lives. So somewhere everything what we do today is getting digitized. So it will also replace our personal lives to some aspects. Like for cars today, we have drivers today. But I am sure in the next maybe 2028 or 2030, we won't need drivers. It will entirely be software. So everything is today being replaced by software, and that is a part of copyright. So copyright will eventually dominate every other aspect of law. Thank you.